What kind of evidence is there that he was driving at any time? How do we know that he was not just hanging out at Speedy's and drinking
Well, you're right.
crazy?
The officer found him unconscious behind the wheel with the vehicle still running at the time. And
I understand that. I understand, but maybe it was for warmth, so he could breathe. What evidence is there of driving?
Hey there, welcome to the Courtroom Files. So this is the third video that we've presented in the last few days from Judge Fleischer's court that involve probable cause hearings. And we're doing this because we noticed in the last couple of weeks that he's getting a lot more inquisitive and asking a lot more questions when it comes to probable cause. He's always been a skeptic, he's always asked questions, but it seems like even more so recently. So we find it interesting. It feels like his
Probable cause DWI hearing. And the judge is laser-focused on one thing: operation. Found asleep, engine running, sky-high breath test. Yet does that legally equal driving? Stay close. A surprise ruling forces creative conditions later.
thought patterns on this are starting to evolve a little bit. So in this particular one, they actually pull in case law to help justify what they're thinking. The defense and the prosecution have a good back and forth, and this one does not necessarily end the way that you think it will. So give it a look. Let us know what you think in the comments about whether or not the judge made a good decision. Put a like on the video if you enjoy it. We're going to link the other two probable cause videos in the pinned comments, so if you haven't seen those, you can go back and take a look. Subscribe to the channel if you haven't already, and let's roll the game film.
For Eric Ramos Amaya.
Yes. Order in the court.
Mr. Ramos Amaya, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to be probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer, a lawyer will be appointed to represent you, sir.
Yes. On October 28, 2024, the officer was dispatched to Hempstead Road in reference to a person down. Upon arrival, the officer met with a witness who advised that around 8:50 p.m., she observed the defendant's motor vehicle to be parked in a parking lot at Speedy's Fast Track and observed the defendant to be passed out.
It's a safe place to stop, very well
in the driver's seat of the car. The witness also observed the vehicle running. The witness attempted to wake the defendant, but he was non-responsive. Upon the officer's arrival, they also observed the defendant to be unconscious behind the wheel of the car with the vehicle running. Upon getting the defendant to exit the vehiol, the officer observed a moderate odor of an alcoholic beverage, glossy eyes, slurred speech, and a swayed stance on the defendant's person. The defendant admitted to drinking. Standard field sobriety tests were conducted. HGN, 6 out of 6. Walk and turn, 6 out of 8. One leg stand, 2 out of 4. The DIC was read, and the defendant consented to breath. The results were .228 and .221.
So you just found him there in the parking lot?
It was reported person down. There was a call that came in. He was unconscious.
What kind of evidence is there that he was driving at any time? How do we know that he was not just hanging out at Speedy's and drinking
Well, you're right.
crazy?
The officer found him unconscious behind the wheel with the vehicle still running at the time. And
I understand that. I understand, but maybe it was for warmth, so he could breathe. What evidence is there of driving? Do you have anyone that sees him driving? Do you have
the witness just sees him parked already with the vehicle running, and that's what
I understand.
and that's what we have. Is the call came in.
Michael, do you have anything else? You know?
Judge, so we have defendant unconscious in the seat of the vehicle and the court's issue.
He's in a parking lot of Speedy's. If he's in the middle of the road, unconscious, that's something, right? If he's in the middle of nowhere, unconscious.
This is the classic Texas fight: operation versus mere preparation. Engine on, driver seat, indicators of intoxication, but no eyewitness driving. Courts read operation broadly. Do these facts cross the line, or is this just parking lot shelter?
he had to have gotten there somehow, okay. How do we know he wasn't inside Speedies?
My opinion is the court is attempting to litigate the issue. This is probable cause. All we have to show is that probable cause is met in the case. He is unconscious in his driver's seat of a vehicle while it's on. That, in the state's opinion, is more than enough.
Driving while intoxicated. It's not sitting in a car.
Operating a motor vehicle.
What proof do you have of operation?
I can provide you, if the court needs case law citations of operation and what is considered enough for operation. If you give me like 5 minutes, I can get
Take your
that for
time,
you.
no rush.
Thank you, Judge.
Really, we got until the end of the docket. Show me something that says just sitting in a car,
Yes,
you
Judge.
know, with it on.
And it's not a public roadway either. It is,
It's a public place, Judge. There's multiple case law.
I get that, but my issue is, how do we know that he wasn't inside Speedies just going nuts on alcohol and he just goes back in his car and just sitting in his car to sleep it off? I don't know that. We don't operate on hunches, right? That's what I'm saying, like, if he's,
assuming that the state is correct in their case law, it still doesn't address your essential question. I mean, let's just say what they're saying for operation purposes. It still doesn't address that at the time that the officer said, found him, he was at 0.08 or higher, or any operation at all while he was intoxicated.
I just want some proof of operation.
I can get you the case law. Yes, Judge.
I'm not asking much. All right, well, take a seat, Mr. Ramos. Well, I'm not ready to rule yet. Whatever it is. Yes. 18 scissors.
Can you send me the case, please? Yeah, I can stick it. He says he has it. We can send it.
He's ready to go?
Right, so there's multiple.
Now we lost the interpreter.
Oh, okay.
Oh, sorry. Okay. What's this? Can you send me the?
So it's Anderson v.
Oh, can
State.
you send me the?
Yeah, I'll email it to you.
Anderson v. State, you say?
Yes, Judge.
What's the code?
I'm gonna send it to you right now. What is his client's name? His client's name is. No, that's not. I'm sorry. What's your client's name?
Ramos. Is that,
This is
it's an unpublished opinion?
Hold on.
maybe I'm looking at the wrong case. This is a sexual assault? No.
No, I think it's the 2010 case. George Anderson.
It's a 2016.
It's 2016.
What's
2016, you
I just
say?
sent it, yeah. I'm just trying to get the closest to what we have here in this case. There's multiple cases that.
Yeah.
Defense distinguishes the state's cases. One had a witness, another a self-admission, plus seatbelts and movement. Also, an unpublished opinion isn't binding. Smart angle. But do today's facts still fit the broad operation umbrella?
It's an unpublished opinion you're sending us.
Sure, but the facts are very
Yeah,
similar.
but it's an unpublished opinion.
Okay, I mean, I can, if you want to give me more time, I can get more case law, but I mean, this is just something that I found in 2 minutes that is very similar.
Take your time.
Okay.
There's really, there's
Just
so much
email
we
me, I'll
have
come back.
until.
Got it.
No,
So give me some time, I'll shoot you an email.
there's just no rush. And then too, Herman, if you find something.
Yeah. Okay. I'll put you on Ramos again. I don't know if you've taken a look at the cases that the state provided. They're very distinguishable, both of them. On one, the Prego case, someone actually sees the driver driving at some point, and then.
I've read about 17 different cases.
Right, and then the second one that the state has provided, the driver self-admits that they were driving at some point, and in both cases, they have the seatbelt on, and there's other evidence of driving and operation, which is distinguishable. In this case, there's no facts that he had a seatbelt on, or he was seen by anyone driving, or he ever admits to driving. So their reliance on those cases are unfounded because it doesn't fit this fact pattern that we have before us today.
So Judge, the first case that I'll refer you to is Prego versus State, which in that case,
Do you email it to me by chance?
I can send you an email right now, Judge.
That's the one the person is seen at some point.
Can I make my argument, Counselor?
No, I thought you were emailing, yes.
I am, but let me
while
at
you're
least make
emailing,
my argument.
I wanted to give him a synopsis of the case.
Hold on.
Let me make my synopsis, and I promise you I'll let you respond.
I was in that reading, I must have read like 17 cases. God. I don't think that there was any case that supported your position. You know, I must have gone through at least 17 or 20.
Well, they have to prove it's a totality of circumstances. Just behind the wheel is not sufficient. They have to provide. Okay.
So let's go to Kennett versus State, Judge. I sent you an email. Did you receive it?
Yeah.
Okay. So in that case, I'm reading just word for word from the case. Courts interpret, quote, operation of a motor vehicle very broadly, and they cite Prego versus State, which is an appellate case. They cite Smith versus State, which is an appellate case. And they say, quote, while driving does not involve operation, operation does not necessarily involve driving. So we have to prove operation of a motor vehicle. Operation does not necessarily mean driving. It states any action that is more than mere preparation towards operating a motor vehicle falls under the definition of operating. So in this case, we have.
Does the fact that you turned the keys onto the car
Is enough, Judge.
That's his opinion. There's no case law that
That's
says
what the
that.
case law literally
You're saying
states.
mere
word
preparation.
for
like
word.
conspiracy, right?
Yes.
The law of conspiracy is, it has to be more, like.
So what did he do other than start the vehicle? There's nothing more than there's nothing more than mere preparation. It was a
that's
hot day, and the Prego case, people see him.
Both sides volley mere preparation like a hot potato. Key turned, AC on versus safety pullover guidance. If the law invites people to stop when impaired, should warming the car later criminalize them? Where do you land?
Have the seatbelt on, which is more than mere preparation. They don't show the seatbelt on. In the other case, the Houston case, it self-admits that they were driving. In this case,
Yeah, I mean, that's right. We're not gonna, if there's a self-admission, that's.
right, and those
now
are what they relied on. The two cases, on the second case that he's quoting, or he showed you on the site, that person, that defendant self-admitted, and there was also other evidence
Have you
beyond mere preparation.
You found any case law to support the position, though?
Well, what position? It's their burden that there was more than mere preparation.
No, but I've asked you to see if you, because I went in back and I literally read through 20 cases.
Yes.
And I can't find any case that supports the proposition that that's not operating.
Well, what they have to show is more than mere preparation. Having your vehicle on by itself is not beyond mere preparation. That is just mere preparation. They have to show either they had a seatbelt on, or the car was in neutral, or something beyond just in the car getting AC on a hot day. I mean,
If you can.
And Judge, there's no, yeah, right.
And, you know,
Right.
I'll certainly look.
I mean, that's what everyone, our legislatures tell us. If you feel like you should just stop and pull over, and that's what he did. And then someone comes at a later time.
There by your admission.
No, I'm not, because if you stop, turn off your car, and then you get hot because you're in a hot vehicle, turn it on, that's not operation. That is not beyond mere preparation.
Where are you getting that from? How are you saying that's not operation? What is your citation for that?
You just stated in your case law that you have to prove more than mere preparation.
Okay.
My statement is, all you have shown is mere preparation. That's it.
But
You have gone beyond mere
But to
preparation.
be clear, you don't have any legal basis for your opinion.
Yes, your opinion is right there when you said it's a totality of circumstances and you have to show more than mere preparation.
And I think the fact that,
There is no case law that says that.
find me something.
Well, that case says it. That case says just turning on your vehicle, you have to show more than mere preparation.
That's not what it says. It doesn't
You
say
read
just
that.
turning on your vehicle is not enough. That's not what it says.
Is that Prego?
This is Kennett versus State.
And then that case is also
I'm
distinguished.
going to read it exactly what I read to you just a couple of minutes ago, Judge. Courts interpret operating a motor vehicle very broadly, and they cite multiple cases. While driving does not involve operation, operation does not necessarily involve driving, stating that any action that is more than mere preparation towards operating a vehicle falls under the definition of operating. So, any action that is more than mere preparation towards operating a vehicle. That does not state that doing this with a key and turning on the car is not more than mere preparation. Our position is that that is more than mere preparation. You've put the key in your car, you've activated your vehicle. That is more than mere preparation. You're attempting to operate the motor vehicle. You don't need to be seen driving the vehicle to satisfy operation.
Judge signals a tentative probable cause finding. Remember, that's a low threshold, not proof beyond reasonable doubt. Translation: the case survives today, but trial remains a different mountain. Next up, conditions that bite without
Under this
derailing
case.
I want to be
employment.
clear, I'm not saying that it has to be seen, but they're stating exactly conversely what I'm saying. You're asking me to show you where just putting on the key is not operation. Well, I'm asking for them to prove just putting on the key is mere preparation, because they're stating a case where the defendant admitted to driving. Okay, in that case, and that is in the facts of the case, and that's what the court relied on, that in addition to this law, that he admitted to
You're
driving.
saying, and can he,
Yes, that
Admitted
defendant
operation?
took the stand and admitted that at some point she operated the vehicle. In the Prego case, someone saw that person driving the vehicle, then they saw him at a later time.
They admitted to driving at an earlier time.
Yes,
They didn't
yes.
admit to driving then.
Yes, that's correct.
Can you point to me to at least one case that shows me where they have found it not to be operating?
No, but I'm also going to state this to the court. Can they show you one case where just having the key in the ignition is more than mere preparation? They haven't shown you that.
I went through 17 to 20 cases, Herman. I haven't found, I looked.
Either way, I bet. Either way, either way. So it's up to the
I didn't
court's
find
discretion.
any, yeah, I didn't find anything to support the position.
Theirs or mine.
So let's do this. I'm gonna find it for now.
Okay.
Go back, do some research.
No, there isn't. I'm very clear on the law. They have to show more than mere preparation. And they haven't in this case.
According to the case law, they have.
No, I disagree, Judge, because because they haven't shown that starting your car is more than mere preparation.
I appreciate it, but the law says differently, you know? Come up, Mr. Ramos. Oh, do we have a translator or no?
And then we have the second issue, Judge, where we have a disconnect about, he
I know, and
cooperated.
I'm gonna bring her up to talk about it.
Yeah, I mean, that's just ridiculous on a first-time offender to have where he did the right thing, even in the courts, pulled over and safely, and it was not a danger to anyone in this case, to have two interlocks put on his, one on a personal vehicle, on a commercial vehicle, where our legislature stated for an occupational license where someone's already been convicted, they can have it just on their personal vehicle and not on a commercial vehicle they're driving. So it's just excessive to have two interlocks, especially where she has multiple vehicles that he's going to have to drive, where he's the manager of the events place and he's all over all the time driving multiple vehicles, multiple trucks for us. And she has a strict policy of no alcohol.
Let me get the translator. Okay, Mr. Ramos,
Order in the court, please.
I'm gonna find that there's probable cause to go forward.
Compromise play. No interlock on the work trucks, but a SCRAM ankle monitor plus 0 alcohol order. That shifts risk monitoring to the person, not the fleet. And the judge flags insurance exposure if an accident hits mid-case.
Para continuar con su caso.
And order you as a condition. Well, let me ask you this. Are you a United States citizen?
¿Es un ciudadano estadounidense?
No.
No.
Are you in this country with or without permission?
Judge, I always tell my clients that it's not to answer it because you're asking them to admit to a potential criminal.
Okay.
Yes.
Está bien.
I want you to understand
Quiero que
one thing.
entienda de que
Not in
una
this
cosa si
country
no
with
está en el país
permission.
con permiso.
And you go to jail and immigration finds you, they will put an immigration detainer on you, and you will be stuck in custody first until this case is over with, and then shipped off to immigration. I don't know what your immigration status is, but if you're not in this country with permission, be very careful. Do you have a Texas driver license? Do you have liability insurance in your name? Okay, you may continue to drive, but I am ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Now, I will order you to obtain an interlock, but you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Your counsel has asked me not to put one on in the work vehicle, but understand that could be a huge liability on your part. If there's an accident and they learn of that he has an open DWI, it could be potentially disastrous to your business. So you need to consider this when you're out there, especially if he's driving and he has an open DWI. It could be very disastrous.
Are you saying that he's allowed to drive one of her vehicles without an interlock?
I know that you are against this, right? What I will do is I'm also a SCRAM monitor on your ankle, so I know that you're not consuming alcohol at any time, and I will not put it on the vehicle, okay? But I want you to understand, these machines are extremely finicky, so you better darn well know anything that you put in your body before, because I don't care what it is, if it's a tequila lollipop, if it's NyQuil, if it's hair dye, if it's isopropyl alcohol, if it's Jesus comes down and tells you to break bread, I don't care what it is. The slightest, faintest, most remote positive alcohol, you will land in custody. Do you understand? Be careful, especially with your insurance, because if insurance knows that if your insurance doesn't know that he has an open DWI and it gets into an accident, they may deny liability. So, you need to really put everyone on notice, because it could be a very big issue. Now, good job on having a lawyer. You've got a junkyard dog for a lawyer who we respect very much. It is your responsibility to stay in touch with Herman. He will tell you if and when you have to come back to court. If Herman tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest.
Bottom line, probable cause found. Case moves forward. No interlock at work, but SCRAM and no alcohol orders stand. Cautionary tale on operation and liability. What's your take? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.